Hi, my name is Andrew Kinney. I'm a Social Security Disability attorney at Hogan Law Offices. I've done this work for about 20 years. I have a series of videos called Social Security Disability. I've gone through Social Security 101, 201, 301. This is sort of a supplemental or an aside. I wanted to do one video on an interesting dynamic I've noticed over the years. I touched on it in a previous video or two. So it's on, I abbreviate it, but federal courts. When you have a Social Security disability claim, you have an application. Most states have reconsideration stage. Then you have a hearing. Then you have what's called the Appeals Council, which is very challenged in many ways. It needs to be fixed, and it's been obvious for a while how. Then we move to federal courts. With federal courts, that is traditional civil litigation. If you have a non-attorney or family member helping you up through Appeals Council and you lose, then you need an attorney to go to the federal district court level. What's interesting is that, and discussing now federal courts for a moment, federal courts interpret, Social Security has regulations that apply to the whole country, but federal courts, they're divided into circuits, and each one has their own take on the same regulations. Social Security's goal is to have unified interpretation of the national regulations. That seems like a valid goal. For instance, if you have a U.S. Postal Service, you would want it to be the same if you go in Tennessee or go in Oklahoma. You don't want different ways to do the same thing. You don't want stamps on the bottom right or upper left. You want things uniform. That seems to be a valid goal. Federal courts are treating the regulations differently, and they can be at odds how to interpret the same federal law differently, which is fascinating. And it all depends on their understanding of Social Security regulations in particular. With federal courts, what you'll notice is that you go state by state, and actually in federal district courts of the lower level and circuit courts of the upper level, you'll notice a wide variation of how they apply Social Security disability law. Now, if you think about it, an intelligent system would not have such wide variation in terms of how to apply. For example, how much weight should you give treating medical evidence? And you'll have a lot of different spins on this. The goal of Social Security disability is to treat people fairly. If we have federal courts, which are a check on Social Security in many ways, but if you have federal courts doing their own thing at the district and circuit court levels, then there is an error. And I would say the error is not in the regulations. The error is in people's understanding of how Social Security works. And so what's fascinating to me is that you can have a lot of bright people involved in all these systems, but they don't catch this fundamental point. If there's a wide variation of how people interpret a regulation, well then people don't understand the regulations. The regulations don't change. Okay. Now, some people may bring up that the U.S. Constitution has been interpreted many ways. Well, if you think about it over time, the Constitution is a fundamental baseline, and we have different variations, some reading into the Constitution, some not, and that's a different discussion. But on a whole, we have a foundation for the Constitution in terms of how we interpret certain things. If we're making things up about it, at least we have the foundation. With Social Security regulations, some of the foundation's eroding away, and it is absolutely a question of oversight. In the federal courts, and I'll say federal district courts, this is the reality. They're very busy. There are big cases that federal courts are involved in. I'm talking about district court level, and there's some smaller cases. Cases get to federal courts if they have a federal question or if there's something involving federal law, okay? The Social Security disability system goes through the federal courts, but by and large, I believe that they're frowned on. They're looked on as little cases, and I would bet that a lot of the law clerks coming right out of school, they're throwing Social Security claims because of the ignorance about Social Security. They think, well, we'll just do these little individual cases. Why don't you cut your teeth on that? If that is going on, that reflects the, well, I'll be strong about this, that reflects the ignorance about Social Security disability. If anyone in the federal court system thinks that that attorneys are good at handling medical evidence, then they should probably think about that. It takes years to understand not only law, but also then understand how medicine interacts with law. Some judges, I think, might acknowledge that they don't get it. A magistrate judge or federal judges, they just don't understand the medical evidence. Well, you need to. We do. We're doing our best. At a Social Security disability hearing, there are some impressions from the federal court that I get. One, and I mentioned this before, that somehow they need to raise objections during the court trial, or at least the hearing. the hearing might seem quaint. But what is more difficult about Social Security hearings that is obviously not getting through is that there is no opportunity for depositions of experts. We're having expert testimony on the fly. We're having people wait 2 years for 1 hour, and we have a compressed time to do what is litigation about someone's whole medical life in 1 hour. So if there is a question about whether an issue should have been brought up or not, we have that context. We also have judges that are not playing a traditional role. There's no government attorney. That would actually make an hour much more difficult. But what what I've noticed is that the federal judiciary, and perhaps telling law clerks, they don't get it all, many of them anyway, I'll say that, is that with this system, you can't object to judges. Inasmuch as someone can't object to a judge in a trial court setting, the traditional setting that has weeks perhaps for a trial, we have 1 hour. The judge is not someone that you object to. If you do, you create, it is a very big problem. It's not traditional rules of evidence that we understand. We are allowed to argue things, but aren't allowed, it seems like things are more lax, but actually can be more difficult. So, what do federal courts need to understand about Social Security disability? One, that the understanding of medicine, don't just defer to the trial court judge, because if there's a denial, there can be total ignorance about the medical problem underneath, and the federal court needs to dig into the medical evidence itself rather than defer to the trial court. The trial court context here for Social Security disability cases, these aren't just facts that are gathered. These are medical evidence already came in. So we have something different than the norm, what was expected. What else do federal courts need to know? They need to understand that Social Security's errors can be repeated over and over and over again. And they need to stop some of the errors. I'll use the weight of treating medical evidence. The regulations are very clear how much weight we should give relative to how long someone was treated by a particular medical source and their specialty area. We have federal district courts and circuits going their own, spinning their own ways. What is the agenda underneath it to make these cases go away? And that should absolutely be against the oath going to federal court, being someone that makes decisions in the federal court context. So I would like federal courts to treat Social Security cases with respect. I would like them to know that one individual is no less important than a multinational corporation that has a lot of money at stake. If someone has not enough to eat, that's just as important as a corporation that may lose millions of dollars. Please consider Social Security cases in the same light as other kinds of cases. Please don't just stick law clerks on these cases. Please make sure magistrate judges understand and respect Social Security law, and that the individual, again, is no less important than corporations. The idea of Social Security disability is that we're taking what we're trying to make fair, what really can't be in the end. Again, we're compressing someone's whole medical life, hundreds of pages of medical records, into a set of limitations within 1 hour, and we're spitting it out, and then they wait another year. A better system would be that we would do the proper filtering at the first stage. It's set up to deny there. The more federal courts ignore the Social Security law, the more that I'll probably push for unification to shore up the bad law that's developed. It is also very clear that in terms of precedent, the normal turn of events for federal courts is to look to precedent for things being overturned a lot, the shepherdizing in the old days. What I would tell you is, if there are not a lot of things overturned, there's a reason for that. We need a solid base of Social Security law and understanding of federal regulations. We need to train, if we need to, law clerks to understand medicine. And if there seems to be an error in interpreting a Social Security judge interpreting the medical evidence, we can't possibly defer to the judge, because this isn't fact-finding in the normal way. There are objective regulations that tell us how to interpret medical evidence. Those need to be followed. If we have a smart federal court system, it would reflect a more aggregate level of cases that work together. We have a lot of interpretations of the same regulations, and again, I think it's a function, and it sounds very strong, but it's a function of misunderstanding how Social Security works, what the format and procedures are, the stresses on the system and particular attorneys, and most importantly, the stresses on individuals who can't work. Please don't look down on them. Please don't put them on the back burner. Please consider them perhaps on equal par or equal footing with every other kind of case that comes into the federal court system. You'll start seeing people accept no review by district court judges if the magistrates are well versed in Social Security law. They're across the board. I'm being blunt. I may get grief for this video, but the truth is important. Social Security disability cases can't go away. It is fundamental to our system that we can help people that can't work. There will be some frauds. You're not going to find them in federal court. They're not going to bother appealing or applying or going into the federal court system. But you're going to have some real legitimate problems, and we need real legitimate thought put to those problems. And I'm feeling like these cases are cast off. If this sounds strong, it's not based on an impression I had last week, last month, last year. It's over the last 20 years. These cases count. Federal courts need to do their job much better, and if they're overloaded, then they need to ask for a unified system of some sort to help. And if that unified system is in there, the understanding is, like bankruptcy, that there would be judges that spend time with medical evidence, because you know what? These decisions are couched in medical evidence, and the vocational evidence is very weak and it's general. It doesn't hold the same standards. Please apply the same attention and care to Social Security disability cases as other cases. If I get grief for this, at least I prompted the question. I think everyone that hears this that is involved in the federal court system, everyone that hears what I'm saying, there's going to be some kernels of truth here. What I'm trying to get at is the truth. I'm not trying to, there are good and bad people that spend a lot of attention, little attention in the federal court system. I understand this is a broad generalization, but on a whole, there's no possible way that the same regulations that have been around for years can be interpreted differently, even next door in another state. Impossible. And the answer is that there's an agenda to push back Social Security claims because of the appearance that these cases don't matter. They matter very much. And as much as one attorney might do 3 cases of litigation in a year, and that would be a busy attorney doing trials for 2 months intervals, if I do 350 hearings a year, and each one is their whole life compressed in 1 hour, I would say that on a whole, this is a different animal, and it needs to get the same attention as other cases. If you disagree, well, you can bring it to me. But all you have to do is look at case law. That's my last little side discussion on federal courts. Sorry to be so strong, but I want to be direct. At this point in my life, what I see is what I see. So hopefully this was helpful discussion on federal courts in terms of policy. If there are some changes in legislation or anything like that, please consider these comments before people just make blanket statements. If you're looking for help with Social Security disability, maybe not federal courts, hopefully not, you feel free to call the number at the bottom of my screen. Thank you.